To the very first topic of today's discussion, this is with respect to judicial accountability in India. India as a state, it has three organs. We have the legislature, we have the executive, and we have the judiciary, right? And in India, we don't follow a strict separation of power. We don't follow a rigid separation of power. What we follow is a system of checks and balance. What does it mean? Let's say if any organ of the state, be it the executive, if it is trying to breach its limit, if it is trying to breach its scope of power, its jurisdiction, we'll have the other organs of the state coming and trying to control it. Or if the judiciary is trying to do something, the executive and the legislature would try to control it. That is what is known as a system of checks and balance. Moreover, what you'll have to understand is, in India, we have the executive, which is the part and parcel of the legislature. That is what you'll have to understand. If you look at the overall picture of the functioning of the state, what you would notice is that the executive and the legislature are subjected to various forms of accountability. Again, I'm repeating. If you look at the overall structure or the functioning of the state, what you would notice is the executive and the legislature are subjected to various forms of accountability. For example, let's talk about the executive. We have the Council of Ministers. And Article 75 of the Indian Constitution very clearly says that the Council of Ministers are collectively responsible to the Lok Sabha. As long as they command the majority in the lower house, they stay in power. We have other mechanisms also. Question hour, 0 hour, debates and discussions, scrutiny by the parliamentary committees. So there is a constant check on the working of the executive. Similarly, once we talk about the legislature, it is accountable to the people. Normally, after every 5 years, we have the general elections. So they have to be accountable to the people. But what about judiciary? If you look at the overall functioning of the state, you would notice is that judiciary lacks the accountability framework or lacks the required accountability framework. And what is the very basis of this discussion today? That we are witnessing a lot of cases where judiciary has shrugged off its responsibility as far as the overall accountability is concerned. Why? Simple fact that generally it is believed that the principle of judicial accountability, judicial transparency, judicial integrity is often antithetical, is often opposite to that of judicial independence. What generally commentators say is that if you want the judiciary to be independent, you cannot let the judiciary to be accountable to the executive or to the parliament, because then the executive or the parliament would try to control the judiciary and its decisions, the decisions of the judiciary would be compromised. By ultimately, what is the very rationale of judiciary? What is the main objective? What judiciary does? It is conflict resolution. And in many cases, what we have seen is that the government is also a litigant. The government is also a party to a case. So if the government has a control over the judiciary, definitely the decisions of the judiciary would be compromised. They would be in favor of the government. That is what many commentators say, who basically put forward the idea of judicial independence. But there's a need to have a robust framework of judicial accountability, because what recently we have seen in many cases, for example, the controversy surrounding Justice Yashwant Verma of Delhi High Court previously, what we saw that there was a hoard of cash which was seen. There was a fire breakout in his house, and what we observed was that there were a lot of cash over there. Similarly, we have had other cases where many of the judges, especially at the high courts, they have publicly called for communal ideas. They've talked about communal ideas in their judgments. And in a recent case, what we have seen is with respect to the NCERT. One of the NCERT books talked about the aspects of judicial corruption, and that was not taken in a good light by the Supreme Court. Supreme Court clearly said that remove this chapter. It says that this in one way is a contempt of the court. That is also one of the aspects. The author in this particular column says that we need to balance this aspect. People cannot go for the contempt of the court, disregard the authority of the court. At the same time, the free speech must be emphasized, must be given importance, and there has to be a balance. So we'll talk about the need of having a robust judicial accountability framework. One of the most important topics as far as the GS2 is concerned with respect to the judiciary. And we'll try to go into all aspects that what this judicial accountability is, what are the reasons, what is the need of having a judicial accountability framework, a robust framework, what are the challenges and what should be the way forward. Believe me, it's going to be a very comprehensive discussion. So let's start. First of all, let's see that what is judicial accountability. What do we mean by judicial accountability? It is that mechanism, it is that framework which basically tries to make sure that the judges and the courts, they are responsible in their conduct, responsible with respect to their decision making, and not just professionally but also personally, so that we have trust in the overall legal system, in the overall justice delivery system. So it is that mechanism or that framework which the judiciary should adopt in order to entrust that feeling of trust in the minds of the people as far as judiciary is concerned, right? And what you'll have to understand is that this accountability framework, it must balance the independence and integrity. We already discussed that. Because the very notion of independence, it sometimes is in a direct conflict with the aspects of integrity. What the judiciary has said time and again, especially the Supreme Court, is that we cannot have a very transparent and clear picture. Because if that would be so, then there would be the infringement of the executive and the legislature in our functioning, and we cannot allow that. In a very famous case, the former Chief Justice of India, he said with respect to the RTI, the right to information, that transparency cannot be used to destruct the institution of judiciary. That was his words, that transparency cannot be used to destruct the very aspect or very framework of judiciary. So that is what you'll have to understand. But we'll have to balance this aspect of independence and that of integrity, impartiality and transparency, right? Judiciary in India, it is not subjected to, we already discussed that, it is not subjected to the same level of accountability as we have for the executive and the legislature. Judiciary has often shielded itself. Very important words you can use in your answer. It has often shielded itself with respect to the aspect of judicial independence. And that in many cases, what it leads to is the possible misuse of power. If you would not allow the people to know what is going on in judiciary, what it would lead to is opacity. People would not be aware of what is really happening. And that would also affect the decision making. That can lead to corruption, misuse of office, misuse of power. So therefore, a proper framework of accountability is important to that limit that it does not affect the independence aspect, right? So let's also have a look at this infographic which talks about that what are the various features of judicial accountability. The very first is upholding the law. Bhai, we often talk about the rule of law. Rule of law, a very important concept given by A.B. Dicey, British jurist. So once we are talking about the rule of law, judges are also equal. They are as equal as the other people. They cannot have a privileged position. We have Article 14, bhai. Equality before law and equal protection of laws. If the executive and the legislature are subjected to the accountability framework, why not the judiciary? It should be subjected to a particular framework, right? Ensuring judges adhere to the legal standards and principles. We have, for example, the ethical standards. You guys are preparing for the paper 4, ethics paper. Why? Because it is expected that the future civil servants who would join the services, they should have a robust ethical framework within them. So it is also, the same thing applies to the judiciary as well. We have the conduct of services rules, the conduct of all India services rules for the civil servants, right? Ensuring justice, guaranteeing fair and impartial administration of justice. This is also very important, because if there is lack of accountability framework, this is going to affect in one way or the other the decision making of the judiciary. So that is what you'll have to understand. Because if judiciary is not really answerable to the people, or if it does not follow any kind of accountability framework, there would be the cases increasing. There would be an increase in the backlogs of the cases. The case loads would increase, and judiciary would not have any incentive or any push to reform itself. Right? Let's talk about promoting transparency, enhancing openness and clarity in judicial processes. Let's talk about, for the example's sake, the appointments process, the appointment of judges to the high courts and the Supreme Court. The process is entirely in the ambit of the judiciary, in the ambit of the Supreme Court. Executive and legislature effectively has no role in that. And the proceedings of the collegium, they are not subjected to public disclosure. Again, I am repeating, whatever goes inside the meetings of the collegium, that body of judges which decides upon the appointments and transfer of judges, it is not subjected to public disclosure. It depends upon their will, that what information is to be disclosed. So that is also one of the very important aspects. Maintaining public trust, building confidence in the integrity of the judiciary. When people would see, people after every 5 years, they vote in the elections, general elections. So there is the accountability framework set. Basis which party gets more number of seats or secures the majority, that forms the government. And then the executive, the council of ministers are regularly subjected to the scrutiny by the parliament. Fine. But what about judiciary? There is no mechanism. Judges are unelected people. How would you enforce that accountability framework? Again, as I've said this before, the analysis part is to make you understand the nitty-gritties of the topic. It's not just about to finish the topic in one go, right? Without even talking about the very basics of the issues. So let's try to understand each and every aspect of it, so that even if a question comes from an adjoining area, you can easily solve it, right? Building confidence in the integrity of the judiciary. So if people have trust, if people have this notion in the mind that yes, our judiciary is transparent, our judiciary is not suffering from the ailments or the malice of corruption, so they would have more trust in the system, right? Safeguarding the rule of law, protecting the legal principles and individual rights. Ultimately, we have the Supreme Court as a guarantor of the fundamental rights of the people. If we have any of the person whose fundamental rights are abridged, what is that article? We have Article 32, right to constitutional remedies, what Dr. Ambedkar said, that this is the most important article in the Constitution. If anyone's fundamental rights are abridged or infringed, that person has a right to go directly to the Supreme Court for the enforcement of fundamental rights. So therefore, people would have more trust in the judiciary if it follows a proper, transparent framework, proper accountability framework. Current framework. What is the framework we have as of now? If you talk about the removal of judges, the first thing which you'll have to understand is that we often see people speaking or using the word impeachment of judges. The word impeachment in the Constitution of India is only used for the president. Impeachment of the president. We have Article 61, which talks about the procedure with respect to the impeachment. Once we are talking about the judges of the Supreme Court and the judges of the high courts, we use the word removal. Same thing goes with the vice president. Same thing goes with the speaker, removal. The word impeachment is only with respect to the president. Once we talk about the removal of the judges of Supreme Court and high courts, we have Article 124 and we have Article 217, subclause 1, subclause B, which talks about the removal aspect. And then we also have the Judiciary Inquiry, Judges Inquiry Act of 1968, which basically talks about the procedure which is to be adopted. And what the procedure says, procedure talks about these things, that the motion can be initiated. The motion with respect to the removal of any of the Supreme Court judge or any of the High Court judges can be initiated in the Lok Sabha or Raj Sabha. And in Lok Sabha, it requires 100 members, support of 100 members. In Raj Sabha, it requires support of 50 members. It can either be accepted or rejected by the presiding officer, that is the speaker or the chairman in case of Raj Sabha. After that, once it is accepted, what the speaker or what the chairman or what the presiding officer would do is, he would set up a particular committee, inquiry committee, comprising of the Supreme Court judge, Chief Justice of a High Court, and as distinguished jurist. This committee would investigate the charges. If it finds not guilty, the case is closed. If it finds guilty, we'll have the house, that particular house, either Lok Sabha or Raj Sabha, it has to first pass this motion with special majority of the total membership and that of the 2/3 present and voting. Then the other house would pass with the special majority. And once it is passed by both the houses, you will have the president order removing that particular judge from that particular day. But the irony is that this procedure has not been used or has not manifested in the removal of any of the judges. We had in 93 a particular case against Judge V. Ramaswamy, but the ruling party did not support it. And it basically, the procedure failed. That's the only one case which we had. So that is what you'll have to understand. Only one proceeding and that too failed. Justice V. Ramaswamy, right? As I told you, we have the Judges Inquiry Act and the other aspect, for example, the in-house procedure, we'll talk about that. The investigative procedure, the procedure with respect to how the things would be carried out. Once you're talking about the removal of judges, as far as 124 subclause 4 and 217 subclause 1 subclause B talks about. We have the Judges Inquiry Act. Then we have Article 235. What does Article 235 says? It talks about the control of the respective high courts on the subordinate courts. So this, in one way or the other, it is an effective mechanism through which the high courts, respective high courts, can have a control over the subordinate courts, right? Then we have Restatement of Values of Judicial Life, 1997. Now, this was basically a charter. It was a voluntary list of items which basically talked about that what should be the conduct of judges. And they were, in one way or the other, the restatement of pre-existing and universally accepted norms, guidelines, procedures, not something very unique. And later it was adopted by all the high courts. Again, this was voluntary in nature, right? Then we have in-house procedure. We had a very important case of Ravi Chandran Iyer versus A.M. Bhattacharjee, 1995. Ravi Chandran Iyer versus A.M. Bhattacharjee. In this particular case, the Supreme Court talked about the idea of having the in-house committee. What is in-house committee? That we would not want others to interfere. We would constitute our own in-house committee comprising the judges, and then we would look into the matters of misconduct. One thing more which I'll have to talk about here is that once we talk about Article 124 and 217, what are the grounds of removal? It's proved misbehavior and incapacity or incapacity. It's proved misbehavior or incapacity. So only for these two grounds you can have the removal of the judges. So we had the in-house procedure, and in 1999 the judges themselves talked about this, that we would have our own procedure with respect to investigating or looking on a particular issue. And if we find that the issue is serious, issue is of grave nature, we would recommend the removal, obviously to the parliament. So it took this particular thing in its own ambit. Then we have the other aspect of Judicial Standards and Accountability Bill. This basically Lok Sabha passed it, but it lapsed. So ultimately what we are trying, and this talked about the National Judicial Oversight Committee. National Judicial Oversight Committee. This particular bill. Judicial Standards and Accountability Bill. But it ultimately lapsed. So these are the frameworks. These are the frameworks which we have as of now, or which we talked about, right? But what is the need to enhance judicial accountability in India? Bhai, zarurat kya hai? What is the need? See, the very first is that judges are there to deliver verdicts, to deliver the orders, to decide on a particular case. And quality matters. That what is the kind of judgment which is being given by the court, be it the high courts, we're talking about the higher judiciary or the Supreme Court. So if we will have a proper accountability framework, the judges would be under a constant gaze of the people. They would be in one way more accountable to the people itself. They would be concerned about their actions. They would be more cognizant of what actions they take, more aware of what they do. So this would usher in quality judgments and permeate justice in society. Because once judiciary would be more active, by active I don't mean to say the overreach. By active I mean to say that once they become more answerable, once they follow a proper accountability framework, it would lead to better quality judgment. And this would permeate the principles of justice in the society, right? For example, let's let me give you an example. We had one of the judges of Bombay High Court who was looking into a particular case of POCSO, Protection of Children from Sexual Offences Act, 2012. And what he said was a very insensitive thing, which many critics said later, that this was very insensitive. What he said was that if a particular child is groped without skin-to-skin contact and the intent of sexual activity, without the intent of skin-to-skin contact and the intent of sexual activity, that cannot be termed as an offense. So this was seen in a very bad light, that what about the children? What about their bodily integrity? So we have had judgments of these kinds. So if we'll have a proper framework, such type of judgments would not be there. Then we have augmenting the public trust and ensuring the impartial functioning. Very, very important aspect of public trust. How would the normal people, how would the citizens trust the judiciary if we'll have cases of harassment? Former Chief Justice of India, there were allegations of harassment with respect to one of the former Chief Justice of India. And later he was given a ticket in the Rajya Sabha. He became a member of the Rajya Sabha. And if you look at what is or what has been his performance as a Rajya Sabha member, it's pathetic. He has not even participated, not even asked one question. So that is the kind of quality which we have. So if we'll have these instances of harassment or anything, the trust of the people in the judiciary would erode, right? Huge backlog of cases, because judiciary, they take, if you must be aware of the vacations. We have the High Court judges and the Supreme Court judges who take long vacations. And you already know what is the condition of pendency. And this data is from 3rd of January 2025. It's a data which is almost more than 1 year old. And look at the pendency. Total case which are pending in the district courts, around 4 crores. Total case pending in around high courts, around 62 lakhs. And total case pending in the Supreme Court, around 83,000. This is the pendency which we have. Pendency of cases. Because there is no accountability framework. Whom are the judges accountable? Who would judge the judges? So that is what you'll have to understand. Absence of any accountability, inadequate existing mechanisms. See, as I told you, we have the Judges Enquiry Act or the in-house procedure. Pehli baat, the very first thing is the Judges Enquiry Act. It has no timelines. The procedure is not time-bound. Let's talk about Justice Yashwant Verma. The matter has been pending. There is no action which has been taken. The constitution of committee, the inquiry committee and the other things, the procedural aspect, there is no time-bound action which is being taken on these aspects. Then in-house procedures. In-house procedures, what you'll have to understand is that it is not subjected to any of the scrutiny outside, from the outside. It is totally a process which is shielded from the outside interventions. As it says, in-house procedure. So these are some of the very important aspects. Balancing judicial independence and accountability. Judicial independence is fine. We need to have the judiciary independent. But what about accountability? In the guise of having judicial independence, you can't just say that you are not responsible or you won't follow the aspects of transparency or integrity or accountability. Absolute autonomy of the judiciary may result in abuse of power, may result in abuse of that particular office, may result in corruption, right? Then we have preventing corruption and misconduct, especially once you look at the lower courts, subordinate judiciary. You must have seen there are allegations that many of these judges, they take money and then adjourn the case for years. Adjournments have been done. The court is adjourned. The case is adjourned. So, and this favors the powerful. So, in a way, the justice delivery system is serving the interests of the elites. We have people, you must have seen what happened in that Kanpur case. We had one of the person who was driving a very luxury car. What happened? These people get bail within hours. What about the common man? Because it is the elites and there is corruption involved, right? Scope of RTI. We had one of the very important frameworks with respect to RTI as far as transparency is concerned. But what about its application in the judiciary? It's limited. We had one of the very important cases of Supreme Court of India versus Subhash Chandra Agarwal in 2019, in which it was very clearly said that the office of the Chief Justice of India, it's a public office as far as the definition of RTI is concerned. But there were certain exceptions. What it said was that with respect to the administrative functions of the Supreme Court, we would give you the information. But as far as the judicial aspect is concerned, the information would not be disclosed. What the collegium is doing, will not disclose. What the assets of judges are, will not disclose. So there are still many restrictions on the ambit of the usage of the RTI with respect to the Supreme Court. Supreme Court is also working for the people, right? It is an instrument of the state. So it has to be transparent. No obligation to prepare the annual reports. We have the ministries, we have various ministries, Agriculture Ministry, Home Ministry. Every ministry prepares an annual report so as to show that what all actions have been taken in the last 1 year, or what have been the achievements, what are the areas where we would work. What about Supreme Court? There is no binding aspect with respect to the Supreme Court to publish the annual reports, or even the high courts. Only few high courts publish the annual reports. So there is no transparency. Then we have global shift towards judicial transparency. You talk about UK, you talk about USA. Over there, what we have seen is that there are oversight committees to look into the cases of possible corruption or misuse of power by the judges. And these oversight officers, they have the investigation power. So this, to a great degree, has led to transparency in the judiciary, right? But what are the potential risks involved with respect to enforcing judicial accountability? Aapne bol diya, you have said that we need to have judicial accountability and transparency. Executive and the legislature must have certain aspects to control the judiciary. But what about the decisions then? The very first is threat to judicial independence. Yes, it is also one of the very grave aspects. Because if the balance tilts in favor of any one of them, there has to be a perfect balance between judicial accountability and judicial independence. Because if the accountability would be increased, if the judiciary would be made more accountable to the legislature and the executive, the decisions would be more politicized. The decisions would be more in favor of the government. We have this issue of quid pro quo. You must be aware of these words. Quid pro quo. You do something for me today, and once you will retire, I'll do something for you. I'll make you the governor. Quid pro quo. So this is what is happening in the judiciary. So if you have the control of the executive or the legislature over the judiciary, it might compromise the judicial independence. For example, we have had the case of Lokpal. Lokpal was also something which was politicized. And it was said that Lokpal would have a jurisdiction including that of Supreme Court. Supreme Court later stayed that particular thing. So this is what you'll have to understand. Political interference in judiciary. Why was this particular motion, removal motion of Justice V. Ramaswamy failed? Because the ruling government abstained from voting. So there were politics involved with respect to this particular judge, right? Then we have discourage bold and independent judgments. If you will have the government of the day and the legislature controlling the judiciary would not be in a position to come up with bold judgments. By politics mein bolte hain na, we often say political will is required. Why don't politicians, why don't leaders take strong decisions? Because they're afraid that it might compromise the interests of the people. Political will is not there. Similarly, if judiciary would always be in that constant threat of being surveilled, of being looked by the executive and the legislature, so they would not pass those decisions which are really important for the nations. It would affect the decision making. Lack of uniform standards. Bhai, you have come up with the in-house procedures, theek hai? But are they uniform? Is there a statutory basis? Is there a law? No. So these are the aspects which you'll have to understand. Now, what should be the way forward as far as the accountability is concerned? The very first is National Judicial Oversight Committee. What we can have is, for example, in this particular bill which we talked about, Judicial Standards and Accountability Bill, it talked about National Judicial Oversight Committee. We can have such type of committee. And if the judiciary is really concerned about the membership, let's have the membership as retired judges. We have legal luminaries, experts in legal domain. We have some of the best lawyers in the country. Why not include them? Distinguished jurists. And on the basis of this particular committee, this would investigate, and then decision can be taken by the parliament. But it has to be a time-bound procedure. Okay. Next aspect is, we have already covered this, reform the removal and inquiry process. As I said, that if you can't go with this, the very first suggestion, you already have the Judges Inquiry Act. Why not come with strict timelines, impose timelines on that, so that people have trust in the system? Okay. Next is mandate the public disclosure of judicial assets. Right now, we have this thing where many of the judges, especially the Supreme Court judges, they come up with their assets and they say that we are declaring assets with respect to what our families have, even the near and dear ones. This is not a charity which you are doing. This is not something, which you are doing which should actually not be done on a voluntary basis. There should be a mandatory disclosure of assets. By you are delivering some of the biggest decisions. You are taking decisions with respect to some of the most important areas as far as the legal aspect is concerned. So you should automatically disclose, or you should be mandated to disclose your assets, and also of your family and near and dear ones. Statutory requirement. Expand the e-courts and digital case management. We already have the National Judicial Data Grid. So why not? And it's performing in a very good way. But why not expand this thing so that and even at the district level, so that what is the caseload with respect to a particular district court, and even the high courts and the Supreme Court, what is a pendency level, how many cases this particular judge has resolved, what is the quality of judgment. There should be a dashboard, so we can expand that. Effective implementation of RTI in judiciary. See, as long as if there's a matter which compromises, if there's a question in the RTI which compromises the independence of the judiciary, it's fine. But for the other aspects, the decisions, the information should be disclosed. Then we have publication of annual reports, one of the most important aspects. At least there would be an element of trust in the minds of people. Ki bhai, at least after every 1 year, we have these annual reports which are published by the judiciary, be it the Supreme Court or the High Courts. What was done in the last 1 year? What has been the quality of judgments? What all judgments have been declared? And that would also serve as a performance appraisal system for the judges, considering the quality of judgments which have been delivered. Then we have review of contempt of court, as the article talks about. That, see, this is something, contempt of court. Most of the democratic countries around the world, they have actually removed this. Take, for example, UK. It has removed this contempt of court. Why? Because this broadens the very ambit of the court. Anything can be seen as a contempt to the court, that this is disregarding the authority. But there was a chapter in the NCERT which talked about the corruption. We study about corruption in the bureaucracy. So why can't we study about corruption in judiciary? That was struck down. So this is a very insensitive and immature approach, right? So not everything can be taken as a contempt of court. That's what we are talking about. Allow constructive criticism, because that is the very basis of a democracy. And as one of the students very famously said, that judges are not gods. Judges are not gods. They cannot just say whatever they want. The judiciary is also subjected to the same principles which the executive and the legislature abides by, right? Performance review system. We have the collegium with respect to the appointment and transfer of judges with respect to the Supreme Court and the High Courts. What about the functioning of the collegium? What about the performance review? On what basis the collegium is appointing judges to the High Court and the Supreme Court? Because what we have seen is the cases of nepotism. We had former Justice Arun Mishra of Supreme Court. His brother was appointed in the High Court, in one of the High Courts as judges. So I'm not questioning the the credibility or the aspects of his intellect, but there are allegations of nepotism in the judiciary. So this is what you'll have to understand, right? Also, once we talk about the gender diversity, that is not there. Judiciary under Lokpal. Yes, this can be thought. If with proper checks, judiciary can also be included within the overall ambit of Lokpal. Why? Because it has been done in a country like Sweden. And that's the reason we say these Scandinavian countries, they perform very good as far as the aspects of zero corruption are concerned, as far as the aspects of transparency are concerned. Over there, the judiciary falls under the overall ambit of the ombudsman in Sweden. Then we have appointments and transfer. We had the National Judicial Appointments Commission, the 99th Constitutional Amendment Act. That was struck down by the Supreme Court. But what after that? You cannot just continue with the collegium system forever, because this is not transparent. This is opaque. So we'll have to come up with a new system, obviously in concurrence with the judiciary. But this is a necessity, what you'll have to understand. So what we are saying is, see, as one of the organs of the state, it is indispensable that judiciary comes on its own with more robust accountability framework, so that the people naturally develop the respect or trust as far as judiciary is concerned. And there is no doubt, judiciary, since especially once we talk about what all decisions it has given after independence, many of the decisions, they have really protected. They have protected the fundamental rights of the people. The judiciary has acted as a bulwark against the arbitrary infringement by the state, by the executive. But we'll have to come up with certain accountability principles. That is what you'll have to understand, right? Let's have a mains practice question which says, the higher judiciary in India enjoys significant independence, but concerns regarding transparency and accountability persist. Discuss the importance of judicial accountability and highlight some of the challenges. So we have, see, this is also one of the aspects which I really want to discuss. People have issues in finding that what are the requirements of the question. The question says the higher judiciary in India enjoys significant independence, but concerns regarding transparency and accountability persist. So we'll first talk about that what is the framework of judicial accountability and what are the issues, right? So this is going to be the first part of it. Then the second part of the answer, the body, would be discuss the importance. What is the importance of having a robust judicial accountability framework? And also it talks about the challenges. So the third part of the question would be about the challenges. Issues, you can basically, you can talk about the challenges itself. So over here, what we can do is we can talk about the introduction part with what judicial accountability is, and talk about in a flowchart kind of thing that what is the importance, right? Next, we'll talk about in the fourth part as a way forward, because it's asking, suggest a way forward. That is how the body of the answer has to be broken. And finally, you will give a conclusion. Please understand, the conclusion, the way forward is not a part of the conclusion. It's a part of the body, right? So do try to answer this, because answering is only the way through which you can significantly improve your chances of qualifying the examination. And yes, if you're liking the initiative, do not forget to press the like button and also let us know in the comments. Let's go to the next topic.